You call your insurance company after a wreck expecting them to act like the good neighbor from the commercials, and instead, they ghost you like a bad Tinder date. That silence has a name, and lawyers call it bad faith insurance conduct. Bad faith basically means the insurance company broke its promise to treat you fairly when you had a legitimate claim. They took your premium checks every month like clockwork, but when it was time to pay up, they suddenly developed selective memory. Think about it like a restaurant that takes your money for a 5-star meal, then serves you a cold hot dog and says, "That was always the plan." Insurance companies owe you what is called a duty of good faith, which is a fancy way of saying they cannot just make stuff up to avoid paying you. There are a bunch of sneaky moves that count as bad faith, and one classic is flat out denying a valid claim without a real reason. Another is dragging their feet on purpose, hoping you will just give up and go away like a bill collector avoiding your calls. Lowballing is another favorite trick, where they offer you a settlement that would barely cover a fancy latte habit, let alone your medical bills. They know most people do not know their claim is worth more, so they bank on you saying yes just to make the headache stop. Some companies also love the classic move of not investigating your claim properly, almost like they closed their eyes and picked a number from a hat. If they never even reviewed your medical records or the accident report, that is not due diligence. That is just laziness wearing a suit. Here is a wild stat for you. Insurance companies in the United States handle millions of claims every single year, and only a small slice ever get flagged for bad faith. But that small slice still adds up to real people losing real money when they needed it the most. You might be thinking, wait, insurance companies are actual businesses, why would they just skip out on paying? Well, every dollar they do not pay you is basically a dollar they get to keep, so the incentive to stall is baked right into the system. This is where accident injury lawyers become your personal insurance company translator. They know the legal language, they know your state's specific bad faith laws, and they know exactly which red flags mean the company is playing games. A good lawyer can spot bad faith patterns fast, like if the insurer keeps asking for the same documents you already sent 5 times. That is not an accident, that is a stalling tactic dressed up as paperwork confusion. If bad faith is proven, some states allow you to sue the insurance company separately from your original injury claim. That means they could end up owing you way more than they would have paid if they had just done the right thing from day one. Here's a myth to bust right now. Having a lawyer does not make the insurance company hate you more or slow things down as punishment. Actually, the opposite tends to happen, because insurers know a lawyer will catch their nonsense faster than a parent catches a kid sneaking cookies. The real lesson here is not to trust the insurance company's timeline just because they say it is standard procedure. Document everything. Save every email, and if something smells fishy, it probably is. Preparation is your best friend in these situations, because insurance companies count on you being confused and tired. The moment you start asking sharp questions and keeping records, you flip the power dynamic in your favor. So next time your claim feels like it is stuck in quicksand for no good reason, you will know the term for it and the questions to ask. Want to learn more about how accident injury lawyers handle bad faith insurance cases? Check out our links in the description.